Interesting. So managerial positions in the US, like we discussed, you really need to hone down on how this applicant, this candidate, this beneficiary, is performing in the position of a manager, or if you're doing, a first-time individual petition, doesn't make a difference. You will have to prove through your support letter, through your evidences, that he or she is performing in a managerial capacity, has the ability to hire, fire, appraise, review. Those are the fundamental criteria they look for. Okay, the next question we had was, I guess, H-1B focused. What kind of RFEs do you see in the H-1Bs most frequently? Availability of work, specialty occupation, right to control, employee-employer relationship, beneficiary qualifications. This, like we talked about, you will have to rework how you view the SOC code you are selecting for your applicants, if you haven't done so already. This is the time you really need to, before it's the end of the year, before you look into, you already have your sales targets set, I guess, for 2020. The business has a sales targets test. Depending on how your denials are working for you or against you, you need to reevaluate the codes you're using. And whether you do it in-house or you're partnering with a law firm, go to whoever the team lead is or the attorney is. You really need to reevaluate this. And I'm telling you, with the documentation that we discussed, this will make a difference. We have the numbers to prove it. The next question is interesting. Okay. Again, RFEs are a thing of the times, but I'm telling you from experience, you can reduce that to 30 odd if you put in the right documentation, which the law is very transparent about from the get-go. Our support letters start at anywhere between 9 to 11 pages. Everybody who knows the law in this room knows exactly what the criteria is. We put it up front, and our clients see the deliverables, and that makes a difference. Do we have another question? This is a big deal, where when you're dependent on the end client, which most of us are, if I can generalize, there are ways that you can still see. At the end of the day, what the government is trying to curtail is fraud, which has been happening. That's the truth. So how do you prove that you're taking this candidate, be it from India or already there, if it's a transfer petition, placing him or her at an end client location? What is the relationship? So whether you're directly related to the end client as the first vendor, if there's a mid-vendor, whatever your situation is, there are ways to prove it, and the more transparent you are, the better off you have a chance for success. Now, the truth is, the end client might not, in most occasions, give you a letter, which would be gold if the end client gave you a letter. How do you work your way backwards from there to still prove that this still is a legitimate application? Because the end client, if you are the petitioner and there are two vendors in the middle and the end client is the fourth person in the equation, the vendor C and the end client D you will never see that agreement. It's just proprietary for their business. You will still have to deconstruct and you work your way backwards to prove that eventually we are filing this LCA, we are filing this petition for our guy to work at that end client. This is the best we can do. And as long as you can be transparent, as long as it's non-fraudulent, your chances of success will increase. I think that was the last question. Okay. Do you guys have any additional questions for me before we wrap up?
There are questions. So
okay, cool.
Yep. So if you see questions in the Slido queue that you like, why don't you, click those, and then Anindita will be able to answer the most relevant questions for everybody.
The first question, if I read it correctly, is are there RFEs in an H extension? My question is, why won't they be? In an extension, you can take nothing for granted. You will, rightfully so, need to reprove that you still need the services of this professional, that you are now paying him or her at least a level 2, if not higher, prevailing wage. Very oddly, or very seldom, do you see the same MSA stringing this person through for the course of 6 years on an H. So you will need to reprove that this professional, no matter what your SOC code is now working for a new end client. What is he or she doing? And if there are any gaps in this building block, you will get an RFE. So gone are the days where you will feel, oh, it's been approved before, no issues, no RFEs in 2017, I'm renewing in 2020, I'm getting all these RFEs. Or 2016, I'm renewing in 2019, all these RFEs. I'm telling you, and this was law as of 2017, there is nothing that you can take for granted, no matter whether you're filing an amendment. So you just got a 3-year approval for somebody 2 months ago. That gig ended. You need to shift this professional to a new gig, go back to the same blocks that I've been hammering out. You have to show right to control. You have to show employee-employer relationship. You have to show end-client documentation. It's restructuring the case to deserve an approval. That's the reason why you will get an RFE if there are gaps. It's the FLDC, the prevailing wage. It is what is a reference website to be taken for the SOC codes. So go to the same website that you would go to for your prevailing wage determinations. For those, if anybody doesn't know, meet me outside and I'll guide you. But pretty much that FLDC website will lay out every position that is coded. So right down from a CEO, right down to, a gardener, professional, non-professional, depending on. There's ways to read it. You have it there. Why is the SOC code and the ETA 9089 perm different? Totally depends on the case. Most ETA perm cases where it is an Indian company, we do get pressured, we means all of us, get pressured to put it into an EB2 position because of the backlog and the craziness that goes on with the visa bulletin and the availability of visas. So a person could be working as a systems analyst right now, but to put him or her into the EB2 category of a software engineer, you can file, that's a whole other session, which is about perms and green cards, but you can file for a prospective position, which is 1132, totally different code. It doesn't have to match, because a green card can be for a prospective position, and H1 is for the current position. How do you avoid RFEs on specialty occupation as major part falls? I think we've discussed this. Go back to analyzing which SOC code you're using, and you better have a justification why your business, the nature of your company's business, and the nature of the responsibilities the foreign national will have at the end client matches to give him or her this code. The job duties are all there in the FLDC. It's more generic. It's not customized. You can customize it for your company and your needs, but they will give you an overview. There's a bullet point where you can expand. So normally they only show 5, and then you can do expand, and you will get at least an average of 9 to 11 to 13 bullet points. Have your project managers. I don't think it's people in this room. The project managers should really look at it and then match up the foreign national to say, you don't get pressure to do eeny, meeny, miny, mo, oh, this lawyer told us this is the higher percentage of success. No. Because when the RFE comes in, you'll have to back up with documentation. Your SOW job duties or PO job duties will be very different than the code you chose, and then you'll get a denial. So this is a collaborative effort from the team that is asking for this resource right down to you or whoever, your attorney preparing the petition. Do we have less chance of RFE if we prepare a well-sufficient support letter? That's the only reason USI law has, in some cases, 100% approval rating. In some larger boys that we play with is 96.7. It's all in the support letter. I respectfully disagree with who tells you anything other than that. How is right to refusal without RFE impacting any insights on this new trend? We have not had a right to refusal. We've had an intent to deny on 2 of our cases that we just experienced, the month before or a few weeks before we came. And there, both instances, I will tell you, the issue was the education. So one was this example I gave you of biopharmaceutical engineering, and the other was the mechanical drafter. So be careful. This is a new trend. Maybe it will increase in the coming year. Start questioning even the educational qualifications of what is being thrown at you. From your experience at the RFE stage, which documents is the most important to include to get a 3-year approval? I can't answer that question without looking at your RFE. So look, your I-129 typically should request for 3 years. The only way I can answer that question is give me documentation to prove that you have worked for this professional for 3 years, and you'll get approvals. We do this for a living. So if you're showing an SOW that cuts off on December 2019, where's your proof? There are ways to justify, if you're looking for a 2022 extended, that's your 3 years, there are ways, without non-fraudulent ways, that we do it, and we do get 2022. Getting approvals from USCIS without end customer letter, but US consulate are now requesting for letter during visa interviews. Is there any alternative? This is definitely a trend we are seeing. The best we can do, that we can tell you, try a BRM letter. Something to prove this is a non-fraudulent application. It all goes back to that. At the consulate level, if some people are here or will be here tomorrow who've had experience with the consulate, ask them, talk to them. They'll tell you on the other half of the table how they are instructed to review the petitions that we prepare and get approved collectively. Because what we do, we get the approval, right? That's not the end of the job. The visa has to be obtained. So how do you then present the petition that has been approved by USCIS to a consular official? And then don't forget, the third and last step is when the person actually enters the port of entry in the US. There'll be questioning there too. Only once the person enters, admitted for whatever visa, whatever years, your job is done. How would you present RFE for L1 functional manager? What's the evidence? This is, come and meet me outside, who's ever questioned this. This is a long discussion. It's not something. It's functional for those of you who do it. It's not heavily done for the primary reason. It's personnel is easily documented. Function is you have to manage a function. There's a whole bunch of ways you could try and do that. But, if you can document it, you should be fine. Perm will be moved to flag sooner, and your comment to the flag, why was this introduced? I think I like the flag system. I don't know whether I'm ostracizing myself. When we review petitions, both the LCA and the prevailing wage, and then subsequently perm, I think it's a good system. It's a much more easier system to deal with. It's just a matter of getting accustomed to. Some of us are old and set in our ways. It's just, trust me, been there, done that. Just, it's a matter of getting accustomed to. You'll get to like the system. Can USCIS issue notice intent to deny before issuing? Very, very, very seldom done. I'll tell you this about being an immigrant in the US myself. I went there in 1990. I think the US is the only country so far that is very fair. And I say this with 100% conviction. You will never get a denial if you prepare a substandard petition, which you should, in my opinion, if I was the officer. But you will get this RFE opportunity to redeem yourself. The US system is fair. Okay, I'm telling you, these are the criteria. There's 17 criteria, 13 criteria, 5 criteria, whatever it is. And you still put together a mail merge letter, you're not going to get a denial. You will get a chance. So unless there's something majorly wrong in that petition, which whoever has experienced it, you need to go back to what was prepared. Odds are this should not happen to you ever.